Hello and welcome to 60 Seconds with Sergio. I am your host, Sergio Cabanas, attorney at law here in Florida. Thank you for joining me. Today's question is, Sergio, what exactly is a mediation in a divorce case and how does that process work? Well, this is very common. In fact, in just about every divorce, unless it's settled very quickly, the case ends up at mediation. Sometimes it's ordered by the court, sometimes the parties just simply agree to have a mediation in the effort to settle the case. A mediation is basically a private, out-of-court conference where the spouses meet with their attorneys if they are represented by counsel, and they all meet with an independent third person who's known as a mediator. That mediator is not there to act like a judge to make decisions about the case. That mediator is really more of an independent person who tries to find the middle ground or any areas of agreement to help the parties reach an agreement. Once the issues that are in dispute are identified, that mediator will then go between the parties to make offers and counter offers in the hopes of the parties eventually meeting somewhere in a middle ground or at least in an area of agreement on these particular issues. So basically there are four possible outcomes to a mediation. One of them, which is the main hope, is that the parties reach a full settlement to resolve all the matters in the case. That's the ideal result. Another possible outcome is that the parties are not able to agree at all. The third possible outcome is that you reach what's called a partial mediated settlement, meaning the parties are able to settle one set of issues, but still another set of issues remain unresolved. The fourth possible outcome is that the parties simply agree to continue the mediation at a later time. So the advantages of reaching an agreement at mediation, which happens in most cases, is that the parties are able to avoid the risk of going to trial. Of course, all because you go to a mediation doesn't mean you have to settle. There are cases where you simply cannot reach an agreement, such as when the spouse and/or their attorney is being unreasonable, and that can happen too, which means that your best possible alternative would be to simply go to trial. So the ideal mindset to have as you approach a mediation is you settle where you can, but you fight when you must. In fact, that's our motto. We settle where we can, and we fight when we must. I hope this video provided you at least a general guideline as to how to approach mediation. Of course, this is no substitute for a private consultation with a knowledgeable attorney who's experienced in divorce law. Thank you again for joining me. As always, stay informed and stay strong.